Welcome to Rebel Chaser. My name is Gail, and I have another clip for you from the Emma Ryan case. This is Judge Hahn up in Washington, and apparently Miss Ryan is continuing to manipulate people. I'll let you guys watch and I'll give my comments at the end, but it even seems like she's got her attorney to start trying to manipulate the court. Or maybe it was just good luck for her. I don't know. But I'll let you guys watch and I'll give my comments at the end.
All right, guardianship of Emma Ryan, 23-4-00364-08.
Morning, Your Honor.
Good morning.
Amy Powers here for Emma Ryan.
Okay. Anyone else? I have Mr. Baldwin standing in.
Amy Turnbull, the guardian ad litem.
Do we have anyone else appearing on this matter?
Matt and Brooke English, the guardians.
Thank you. All right. All right. Mr. Baldwin, it sounded like maybe you had a request, so.
Mr. Goodday reached out to me, Your Honor. He is out on paternity leave. He's trying to manage court appearances as well, but had a doctor's appointment scheduled, I believe, for their newborn at the same time as court today, so he couldn't appear via Zoom. He reached out asking if we could appear, showed on for review. He wasn't sure if any substantive was intended to happen, but just was asking if he said over to him being available. By the name of his client, nothing came up on a conflict check. Other parties did show up as a potential conflict for our office. I'm not able to handle anything substantive, but he's not able to be here. And I did tell him I would appear on the docket to let the court know why he wasn't present and ask if he said over if anything was to occur for a time he'd be able to appear.
Mr. Play?
Your Honor, according to Josh, Mr. Gooday's email, he's known about this for at least a few days. He didn't inform us that this would be necessary. Again, this case needs to move forward. What's on for review today doesn't really have anything to do with Mr. Goodday, frankly. We're talking about the objection filed by Emma, as well as possibly the review of the jail report. But I think we can proceed without him. He could have informed the court that this was an issue days ahead of time. I'm not sure why we're learning about this right now.
Ms. Powers?
I'm not opposed to a set over. I'm prepared either way.
So I guess at this point, Mr. Baldwin, do you know about the case or do you have any information on it?
I have no information, Your Honor. My notes from Mr. Goodday were just that the matter was on for a review with nothing new. I don't know if he anticipated that there would be argument regarding the objections filed by counsel for the child today. So he was under the anticipation it was just effectively being a body here for the matter. And because I think that I have a potential conflict, I wouldn't be able to appear on the case as in a representative capacity, other than, I guess, to let the court know that Mr. Goodday is not present. If Your Honor doesn't believe he's necessary and he would be excused from the hearing, then I guess I'd be excused from the hearing and I can just go as well and the parties can do what needs to be done. But if it's something that he would need to be present for or have a position on, I can't say. So I'm just letting the court know what his request, what I was informed, that if there's anything substantive to occur, to ask to set it over and provide the court the information that I have. So that's all I can say.
All right. Well, court does, I do wish he would have given prior notice on the request. I did see the objection. I would like to hear at least that much and then go from there. So Ms. Powers?
Yes, Your Honor, would I be excused then? I'm sorry. If Mr. Goodday's not involved, if he's not involved, I'm not, because I at least one party did a consult with our office at some point in the past that I wouldn't feel comfortable representative capacity on the case. So if the court's going to proceed without him, then I'll let him know that and he can check FTR. But I don't think I should be standing in any way, shape, or form, other than just to inform the court he's not able to be present. That's what I told him I would be able to do.
Okay, go ahead.
All right, thanks, Your Honor. Following our last hearing, Emma reached out to me pretty quickly after the last hearing and had some pretty strong feelings about what was happening. I've spoken with her over the phone on 3 different occasions. We have communicated back and forth minimally through text message and email. I've tried to keep everything on telephone because that seems the most reliable shot I have at hearing from Emma without other influences. Through our phone calls, she expressed very strong opinions about what was happening in this case and wanted to make sure the court was aware of her feelings and her perspectives on this. That's why we went ahead and filed an objection so that her voice could be heard. She did not feel like it was accurately heard through the guardian ad litem report. So that's why we went ahead and submitted the objection so that the court would have that information. I will be transparent with the court that I had phone calls with her. Because they were phone calls, they were not as reliable in terms of if I'd been able to meet with her face to face in a neutral location. But the telephone calls were with somebody that reliably sounded like a teenage girl, and I believe that they were Emma, and so we have filed that objection.
Mr. Flay?
Your Honor, I think this plays into the narrative that we've seen from Lauren Ryan this entire time. Why can't Emma meet in person? Why does Emma have to be on the phone? Why are there limited text messages that are the only correspondence that unfortunately Ms. Powers is able to have with Emma? Even if Emma is the one saying these things, what is gravely concerning is that she's under the helm of a person who has been controlling her and controlling everything she does since September outside this court's order. So it's haunting me, and I think the court in general, that we've now come to the point that I don't think that Emma is able to even accurately think for herself. Whether or not she believes this, I think it goes outside the scope of what is the best interest of the child here. I think that she's been far gone at this point to whatever is a semblance of normalcy. We're talking about a child who's been living as a vagabond for, over 6 months now. Of course, Lauren Ryan's told her that my clients are the bane of existence. I mean, what else have we learned from this case is that Lauren Ryan will do anything and everything to make things go her way. So I respect what Ms. Powers has done. I think that she gave an accurate representation of the court, and even by her own admission, she cannot fully confirm that necessarily this may or may not be Emma saying these things, or at the very best, she hasn't said this is my position, that even if Emma is saying these things, that she's not working in her best interest. This is not the best interest of Emma. It is not the best interest of the child. It's below the standard of what is necessary for this to be dismissed. So we'd ask Your Honor that the objection be taken with that grain. I do not think that Emma knows what is in her best interest, because unfortunately she's been living in a warped world that is far, far from what the best interest of a child is. Thank you.
Ms. Turnbull, anything?
Yes, I think that my report spells out the lack of stability in Emma's housing over the last number of years, as well as the lack of stability and education that she has received over the last number of years. And that points to Ms. Lauren Ryan's inability to provide for educational and frankly parenting responsibilities by statute for Emma, and whether or not Emma believes that she is that what are in her best interest. It's clear that Ms. Ryan is not providing for her by statute, and that's not in her best interest. And I would agree with Mr. Flay. I don't think that she really has a clear sense of maybe what's normal at this point, given all of the chaos that she's been subjected to.
Anything
Can I have
further from anyone?
Can I have a brief reply, Your Honor?
Go ahead.
Just as Mr. Flay was talking about Emma's best interest, I just remind everybody that as her attorney, my job is to represent her stated interest. And she was pretty clear that she does not want to live with the Englishes. She'd prefer to stay with her mother. If that's not possible, she'd prefer to go to her maternal grandparents. And then lastly, her concern was that she has seen social media posts. Brooke English was involved in them, and they were embarrassing to Emma and felt like an invasion of her privacy.
That was one issue of concern. Mr. Flay, are you aware of such posts?
Your Honor, I am aware. After reviewing the objection, I've instructed my clients to refrain from that in the future. I was unaware of those posts prior to the objection, so I would advise my clients, and that will no longer be an issue.
So in regard to the objection, it's noted, and at this point, again, for all the reasons and concerns, we don't know under what surroundings the objection and the conversation with Powers was made. This is a child. Child doesn't always know what's in the best interest, and at this point, I just don't see any reason to change anything. So I do caution everybody and your clients to please refrain from putting this on social media. It's not appropriate. So that is not to happen again. That said, my thought at this point, I did review the guideline report, and it just seems like this matter needs to be set for trial, and not sure what else to do at this point. Any thoughts?
I'm not against that. I think procedurally we're in such an odd spot as we're not even in the general guardianship phase yet. So I'm not opposed to a trial. I think that's ultimately where this is going to go. But my concern is that if there's going to be procedural issues of Miss Ryan not even letting this get past an emergency guardianship, I worry about her ability to appeal because of that procedural issue. So I guess maybe there needs to be more research done. It's obviously a relatively new area of law. Probably the court didn't anticipate the situation this severe. So that's my main concern. But if the court's comfortable, that's obviously up to the court, and I'd be happy to, I guess, memo the issue. But again, I don't know what would be found given that it is such an odd situation.
Can I weigh in a little?
Go ahead.
My thought is that if I'm understanding the statutes correctly, the emergency minor guardianship order really is only supposed to be 60 days, extended one time for maximum of 120 days. The first emergency minor guardianship order was entered in January. We've really basically exhausted that remedy under the statute. So it seems like we do need to go to a hearing on the full guardianship, and potentially, although I do recognize it's definitely a strange case.
Yeah, and I'll tell you, one of the questions that I've had is when you have a parent that's been out on warrant for some time, if that in any way stays the time factor. I just don't know. And like Mr. Flay has said, it's new law, and so not a lot to rely on.
And Ms. Powers, just to clarify, we have requested and attempted to do the next steps for the general minor guardianship, but because of Ms. Ryan's inability to frankly do anything in this case, it's kept us from moving further there. And again, the court has felt, I think, uncomfortable jumping that step without the child actually being transferred. Sorry to speak out of hand, Your Honor. I just wanted to clarify that.
That's fine.
And I guess I'm not understanding which step is missing or which, I mean, I know that the transfer of the child has not occurred, that there's been holdups there. I'm just trying to understand procedurally what is the missing step?
Mr. Flay, were you?
I think, given Judge Warning, previously on the case, and I disagreed with this initially, but I think that the hangup was that the court was unwilling to move from emergency minor guardianship to the general minor guardianship, given that the child's not in custody or in the guardian's custody, and therefore, because of that, they're unable to really even call this a guardianship. Basically, we're in this holding pattern of, okay, this can't move forward until the child is transferred. So I see the court's reasoning there. I've asked for a review on the general guardianship, but usually that's kind of the answer we get to is this is still technically in that stage because no transfers happen. So because the basis for the general minor guardianship is that we're reviewing what the care of the child is like in the English's home, right? So if that's impossible, then I guess we just don't really have anywhere to go. So that's I think been the court and our hang up as well with everything.
So I would prefer to have also Mr. Gooday or somebody that can actually be here and represent the mother, be present. Ultimately, what I would like is for everyone to do some research and try to see if there's any guidance, even from the old laws or anything within the old law that can maybe be used. And I think this law is, although new to Washington, I'm not sure it's necessarily new and I don't know in other states. I just don't know. But why don't we go ahead? Mr. Gooday is not here. Like I said, I don't feel real appropriate to do anything substantive as such today, since he's not here, understanding why and what's going on. But let's go ahead and set this over 2 weeks and have Mr. Gooday here. But meanwhile, do some research, see if you can find something that maybe can give some better direction to the court as to next steps. I'm at a loss, honestly.
Your Honor, are we again doing an order extending the emergency minor guardianship?
I'll go ahead and do one.
Thank you, Your Honor.
Your Honor, just one other little brief question. I have almost used up my 10 hours court appointed on this case, and so I was going to send over an order asking for some additional hours. Can I send that over ex parte, or do I need to note that up?
You can send it over ex parte. We have a different judicial officer reviewing those.
Okay.
So just send it over.
Thank you.
Thank you. All right. So not able to really do much today, kind of in a gray unknown area of what to do. So do some research and we'll try to look closer at it. And hopefully Mr. Gooday will review FDR and do some as well.
Your Honor, would you like us to prepare, if there's enough information, prepare some sort of memo before the next hearing? If not,
That would be good if you have something.
Sounds good, Your Honor. Thank you.
Okay, thank you. All right, that concludes that matter.
There's something very suspicious when immediately after the last hearing, and we didn't get to see that hearing. They either didn't stream it or it was in person and they didn't show it, but we didn't get to see it. But it's telling that immediately after that hearing, Emma supposedly calls the GAL and says, I don't want any of this. I want to stay where I am. So could she have Stockholm Syndrome? Could she have been told so many evil things about the Englishes that now she'd rather stick with the evil she knows than go to a place that she's been told is horrible. And why can't she meet with the GAL in person, in private? That person, the GAL, is there for Emma's benefit. So why can't she meet her privately, all alone, without her mom giving a script to her to read? Why isn't she allowed outside of that protective barrier? And of course she's going to say, I want to be with grandma. That's what mom's told her to say. I think that it's imperative that they get her away from that woman, that family, both the mother and the grandmother. That's my opinion. Now, other people may have other opinions, but she's already had one child taken away from her. Maybe possibly two. I've heard that maybe she had a son taken away from her. She's had a son that's turned 18 who has then gone to the courts and said, my mother beats us. That happened in the other case where mom and grandma hid that child from the world, also from the people that were trying to protect her. So we'll see in 2 weeks. Of course, she never showed her face again today. And, is her attorney using this to help her? Is this true? Did he really go on leave? I don't know. I don't know. It seems suspicious to me, especially when he didn't tell anyone until this morning. Hopefully, he's not unethical and he's not doing that on purpose. I really hope he's not. But anyway, the Englishes showed up as usual, and they're always, they always look good. They're always clean. Their home looks nice. They seem like nice people. Unfortunately, Brooke is not going to be allowed to update us any longer on what's going on. So we'll only know what is in the hearing. So anyway, thank you all so much for watching, and I'll see you next time.